Circular 230 Section 10.29 is all about conflicts of interest. On the EA exam, they test two things. Can you spot the conflict, and can you document the waiver correctly? A conflict isn't just awkward. It's a defined ethical problem that can restrict how you represent a client before the IRS. Divorce, partners fighting, and multi-party returns are classic fact patterns. A conflict exists in two main ways. First, direct adversity. Helping one client hurts another client you represent. Second, material limitation. There's a significant risk your work for one client is limited by duties to another client, a former client, a third person, or even your own personal interest. The exam loves significant risk language. Don't water it down. Here's the key. A conflict doesn't automatically mean you must withdraw. You may continue only if three conditions are met. 1. You reasonably believe you can provide competent and diligent representation to each affected client. 2. The representation isn't prohibited by law. 3. Each affected client gives informed consent and waives the conflict. Miss any one of these, and you can't represent them both. Informed consent means the client understands the conflict and the material facts. And Circular 230 adds a documentation trap. Consent must be confirmed in writing. If you first get consent verbally, you have 30 days to confirm it in writing. On the exam, watch for timing. A signed waiver months later doesn't fix a non-compliant process. Your written consent should, at minimum, describe the nature of the conflict and identify the parties you represent. Think of it like a clear map: who you represent, what the conflict is, and that they waive it. In a divorce, that's usually both spouses. In a business dispute, it could be each partner and the partnership entity itself, because all are affected clients. Finally, retention and production. You must keep the written conflict consent for at least 36 months from the date the representation ends, not from the tax return due date, not from when they signed, from when representation ends. And if the IRS asks, you must provide it to an IRS officer or employee. This is a favorite EA exam detail question. Danielle is an enrolled agent representing two clients who are going through a divorce. There's a clear conflict of interest, but both taxpayers want Danielle to prepare their returns anyway. She has a signed consent form from each client waiving the conflict. How long must Danielle keep these consent forms? Think about whether the clock starts at signing, filing, or when representation ends. The correct answer is 3 years from the date representation ends, meaning 36 months after the engagement is over. Circular 230 ties retention to the end of representation, not the return due date and not the signature date. The tempting wrong answer is 3 years from the due date, because that sounds like typical tax record rules, but Section 10.29 uses a different trigger. What is considered a conflict of interest in IRS representation? One option describes a case where the enrolled agent's work is materially limited by responsibilities to another client. Other options mention getting informed consent in a dissolving partnership, differing political views, or representing a still married couple on a joint return exam. Which one is the conflict under Circular 230? Think about it. The correct answer is the situation where representation is materially limited by responsibilities to another client. That's exactly the significant risk of material limitation conflict in Section 10.29. A dissolving partnership with informed consent can be permissible, so that's not automatically a conflict you can't handle. And political differences are irrelevant unless they create a real limitation on representation.